There is a message from Shruti. If Debanjan Bhai, would you like to read that?
You are live.
Basically, the attendees can hear us and see us as well.
Oh, they can all.
It's all right. I mean, we have not been talking anything which is below the belt.
Yes, absolutely.
It's not like, Kunal Bhai, what happened on a very lighter note. Yesterday there was a judgment which was being delivered, and the judges were late. So there we have Mr. Mitra sitting in his court uniform in his chamber, enjoying his cigar, and he is not aware that he's doing that. Everybody could see him. So I told him that Mr. Mitra, smoking in public places is not allowed. And then he realized.
But Debanjan, you also say that was a lucky omen.
Indeed.
We won the case hollow. Absolutely, we won the complete victory. So maybe I should light a cigar now.
But was the cigar the lucky omen, or was the nightmares or the dreams the lucky omen?
Well, that we can't share. So let's not talk about it. Let's keep it to the cigar.
Mr. Chandra Shekar, you are based in Chennai now, or where do you stay, Mr. Chandra Shekar?
I'm based largely at Hyderabad.
Hyderabad.
To be splitting my time between Delhi and Hyderabad before the COVID thing. 2 days a week I was in Delhi. But of course, post this problem, I've been tied down completely at Hyderabad.
I have a feeling that my video has gone still, so I will leave the meeting and join back again.
You are still.
Oh, I'll just leave the meeting and join back.
Who is this Mr. DPR, Mr. Dhiren Singh?
Yeah, DP Singh is my colleague. He takes care of administration for North India. I am from Delhi.
Oh, you're from Delhi?
Yeah, I'm a Bengali, but I'm from Delhi.
Well, I'm calling you Devmalu. You're much younger than me.
Absolutely. So, but my span of action includes North India and South India. So Hyderabad also we have an office, Bangalore we have an office. So, then there are, relevant people there who are managing the territories. But overall scheme of things, I manage from Delhi.
Good.
Okay. Interesting combination of region, which I've never seen before.
Yes, everyone says this. North and South India normally doesn't happen.
Yeah.
So normally it is East and North or West and South kind of. But for me, the organization decided North and South.
So are they actually North and North plus South, or is it just one region which consists of North and South?
No, it is North plus South, because our operations are there in Bangalore, in Hyderabad. We have a proper regional head there who manages things. And then they have a team for him. And then we do a lot of actions in Kerala. We do plenty of actions in Karnataka, Bangalore, Hyderabad. We work very closely with government. So you must be knowing Rajiv Reddy, Subirami Reddy's grandson.
Yeah.
So Rajiv chairs our Southern Region Council. So our office is in TSR Towers, Somajiguda.
Okay. That's close from where I am.
Yeah. So our operations, and we also work in Kerala very strongly. Rajesh Jha from the Adanis, he chairs our committee there.
I see. Okay.
So I could see now close to 70 people already. So we'll wait for
the people may leave if you don't start. That's
right. So
let us start, Debanjan.
Yes, absolutely.
Okay. Good evening, ladies and gentlemen. Good evening to all of you, wherever you are. In the day and age of of internet and we have now webinars. Basically a seminar on the web. This is a webinar. I mean, this is something which was new to me till the lockdown happened. So at least the lockdown has changed my life in this way, that I now know what a webinar is. In any event, I'm so happy that we have got a distinguished panel here today. Let me introduce myself. I am Debanjan Mandal. I am a lawyer by profession, a partner at Fox & Mandal. I also chair the National Legal Committee on Corporate Affairs and Legal Affairs of the Indian Chamber of Commerce. And I am the Associate ICC for a very long time. We have with us Mr. Kunal Bhajani. Kunal Bhai is also a lawyer of repute. He, apart from, he is a leading dispute resolution practitioner and head of chambers of Blackrobe Chambers, New Delhi. Kunal, holds the distinction of being the court member of ICC International Court of Arbitration, Paris, as well as he is a standing counsel of the Municipal Corporation of Delhi. Kunal Bhai, originally from Mumbai and with a master's from Harvard Law School. He qualified as a solicitor of the Supreme Court of England and Wales. Kunal Bhai specializes in litigation and arbitration, and his practice ranges across a wide spectrum of civil, criminal, and company matters. He has been an arbitrator, both a sole arbitrator as well as a member of a 3-member panel in a number of institutional and ad hoc domestic and international arbitrations. He has a vast experience, and apart from anything else, he is also co-chairing with me the committee of ICC on national legal affairs. So welcome, Kunal Bhai. I mean, you're part of the ICC, so, but thank you for being a panelist. Thank you for agreeing to moderate.
Thank you.
And I now move on to Mr. Abhrajit Mitra. Mr. Mitra is based out of Kolkata. He belongs to an illustrious family, and he is a senior advocate of the Calcutta High Court. Mr. Mitra is has got his MSc in economics from the London School of Economics and an LLB from the London University. So there's economics, there is law, and he was not satisfied, so he also did his chartered accountant. He's a chartered accountant from India. So here we have a perfect blend of somebody who knows the books, who knows law, who knows economics, and he is one of the leading lawyers of Kolkata, and a large number of judgments to his name, reported judgments. Thank you, Mr. Mitra. Thank you for joining us today.
Thank you for giving me this opportunity, and Mallo, I hope.
And of course, we have Mr. Chandra Shekar. Mr. Chandra Shekar, just now, before the seminar started, we were discussing. He splits his time between Hyderabad and Delhi. Mr. Chandra Shekar is a highly respected and a well-recognized figure in the IT and telecom sectors, both in India and internationally. He is currently the chairman of the Center for the Digital Future based at Gurugram. Additionally, he is associated with several organizations in advisory roles as well as board positions. He is the former secretary to the Government of India for Electronics and IT, as well as the chairman of the Telecom Commission of India and Secretary Telecom, and later as president of NASSCOM. NASSCOM is the National Association of Software and Service Companies. So he possesses a unique breadth of experience and expertise, both in the government and private sector. He was a member of the country's premier Indian Administrative Service. He was an IAS officer since 1975. He retired from the government service in 2013 with an impeccable record. Thank you, Mr. Chandra Shekar, for joining us.
Thank you for having me on the panel.
So with these few words, I will then briefly tell the audience today the objective of this webinar is to discuss the contractual obligations and the challenges faced by the Indian industry arising out of this the COVID, the pandemic. I know that my video has again gone, but I will not stop my introduction. I will just finish my introduction, and then I will probably have to restart. The webinar would aim to discuss. Can I be heard?
Yes.
Yes, you can be heard.
The webinar would aim to discuss the contractual issues, the delivery issues, the criticalities and challenges which enterprises face in honoring customer contracts. Due to the lockdown and corresponding negative sentiments, quickly adapting to a new way of working, changing work patterns, principles and dynamics overnight, and at the same time, seamlessly delivering as per customer needs may not be possible for the Indian industry. The webinar would aim to discuss such challenges. Mr. Kunal Bhajani has kindly agreed to moderate. So Kunal Bhai, I leave it to you now. I will be briefly disconnecting and again reconnecting, hopefully this time with video.
Thank you very much, Debanjan Bhai, for your kind introduction and generosity of words as always. Thank you very much, Mr. Banerjee, for having all of us here this evening, and I welcome all the attendees. I see the number has just shot up very high, but I don't think we can now wait any longer because we have a lot of people in attendance. So, Mr. Banerjee, may we proceed and begin now?
Yes, Kunal Bhai, we can start.
Perfect. I think we're at a situation where we're lucky to have somebody who has a bureaucratic experience, and particularly from what has saved the time, technology, which is Mr. Chandra Shekar. And we have somebody who is also a legal expert and analyzing the situation very closely. The situation as it stood, that the government of India ordered the lockdown on 24th of March as a preventive measure, left everything completely unanswered. Most businesses were also left grappling with legal issues that impacted their operations, to which also there were no answers. To take this discussion further, Mr. Chandra Shekar, what are the situations that you have seen in the last 45 days with a single day shutdown and all the three lockdowns, 1.0, 2.0, and the really challenging one, which is now ongoing, which is 3.0. What do you see the India Inc. Corporation facing? What do you see the India Inc. Corporation grappling with? Or is there a kickstart? Did we really kickstart also in the last 2 days with all the relaxations that we saw coming in from various state governments?
Thank you, Mr. Bhajani. I think you have laid out the backdrop against which this discussion is happening. We are truly in a unique situation, which has probably never been seen before. You know, India's response to the COVID-19 has included the strictest government-mandated nationwide lockdown seen anywhere in the world. And obviously, you know, all economic activity ground to an abrupt halt as both a direct and intended consequence of this measure. And a large part of non-essential government activity was also shut down, including transportation, public, private, all of that. So while essentials continued and digital activity not only continued, but in fact, in some parts saw heightened activity. But the effect of this situation was, which we have seen, is that entire supply chains were disrupted. You know, for all of manufacturing, they all depend on supply chains, both within the country and outside. And all of these supply chains got disrupted, both because of closure of factories, as well as cessation of transport. And manufacturing also stopped suddenly. And even services that involved any movement of people, I think all of that got completely derailed. As a result of this situation, fulfillment of all contractual obligations, you know, became an impossibility for the entire duration of the lockdown, particularly in phases 1 and 2, excluding, of course, a few areas relating to essential commodities. But even today, when we are in the second day of lockdown 3.0, or when we are in the second day of a partial lifting of lockdown, what we are seeing is that, you know, while the shutdown was instant and extremely effective, resumption is actually happening and likely to happen very gradually, sporadically, and unevenly. because different parts of the supply chain have got disrupted, and they're not all coming together. We've seen issues with the movement of labor. We've seen issues with respect to units which might be located in red zones and so on. So the restoration is actually both is gradual, sporadic, and uneven. And then we also have the backdrop of the RBI's interventions, which have another set of implications, including the announcement of 3-month moratorium on all loan repayments, the implications of which are being understood and digested by the companies. So now this disruption, what we are seeing and what I have been hearing from our colleagues in the business and industry, it has impacted both the suppliers and the buyers. Not just the suppliers, it's impacted both suppliers and buyers. And it covers both goods and services, not just goods, but both goods and services. The other dimension is that because this is a global pandemic, and a lot of the countries with which we do business, USA, UK, Europe, Middle East, and obviously China, where the whole thing started, all of them are affected. And therefore, this problem affects both domestic and international businesses. Specifically with regard to the IT and the IT-enabled sector, from a supply side perspective, that is the Indian entity as the supplier, the impact was somewhat less severe, although it was quite significant, because it was recognized as an essential service and certain dispensations were given to enable them to continue with their business. But the worry there is somewhat different, that even if the supply side was under control, the big worry was on the impact on the client side, at the overseas or domestic location, because of the disruption of their business. Entire sectors like aviation, tourism, travel, hospitality were disrupted. So naturally, the business which rested on them or provided services to them collapsed. So as a result of all of this and the fact that contractual obligations were not fulfilled either because of constraints on the buyer or the seller, a lot of legal questions have now arisen, which people have begun to think about and are troubling them hugely. And I look forward to hearing some of the thoughts on some of these legal issues, but I will highlight a few of them just to sort of indicate what are the kind of things that worry the companies the most. So questions like, what are the legal implications of contractual failure across all of the situations that I've just mentioned? Who will be liable for losses which are incurred as a result of breaches of the contract? Will a buyer still be liable to pay for goods and services where the seller has fulfilled his part of the obligation? In the case of digital services, if the provider was ready to provide the services, but the buyer was not ready to consume them because the demand has evaporated, will they still be liable to pay? Now, the situation that we are in is both a natural disaster and a case of sovereign intervention. And the big question that has, elephant in the room is, how will force majeure be applied? To what extent will contractual provisions be enforceable? And will this situation that we are in void some or all of the contractual provisions? To what extent would these contractual liabilities and penalties be applicable? And to what extent can the supplier or buyer seek relief by recourse to force majeure or any other provisions? And to what extent will the RBI directives impact business contracts and our payments that are in the pipeline? And how will all of these issues play out in an international context where you have the legal framework in both countries coming into the picture? So a lot of these kind of questions abound. And I think we need to think about them comprehensively and dispassionately. And I look forward to hearing the views of the legal luminaries on this panel on some of these issues and share some further perspectives on them.
Thank you, Mr. Chandra Shekar. So what we hear from you is a ramification which is bilateral, a situation which is non-intentional, and a breach which is beyond control,
Yes.
which all culminate into what is a French concept called force majeure, which translates into two words in English called superior force. Mr. Mitra, I know personally that you've had views on force majeure, both positive and negative. And I think it's time that before we proceed to the multiple questions that Mr. Chandra Shekar raised, we get your views on force majeure alone, both the positive as well as the negative.
Well, Kunal, force majeure is age-old doctrine which is a common law doctrine called law does not compel someone to perform an impossibility. Now, there are two situations. One is where there is a force majeure clause in the contract, which is mostly there in commercial transactions, except leasing of land or space. Now, commercial transaction, if there's a force majeure clause, then let's forget about everything else. That clause will prevail. If it provides for a pandemic of this situation, it normally will. It will be epidemic or act of God, and our coronavirus fits in perfectly. So it will depend on whether the court will consider this to be a situation which prevented a party from performing a contract. Now, I will demonstrate with the help of maybe a slide or so, my office, if they can install it. Now, let me come to a situation. Firstly, let's take this first case. Standard Retail versus GS Global. In this case, a Korean company was supposed to supply certain goods. It's an Indian company. GS Global is the Korean company, and the Standard Retail is the Indian company. Now, Korean company affects the shipment. An Indian company then goes to court and says, this is a force majeure situation, and I will not accept the goods because my customers, none of them will take the delivery of the goods. I can't unload the cargo from the vessel. And on that basis, they wanted to stop the payment, which was to be made against a letter of credit. The Bombay High Court said no. I think it was Bombay High Court said no, I will not grant that injunction. Why? Because the clause in the contract said that a force majeure, in a force majeure situation, including an epidemic, the seller will have the right to not supply by giving a notice of a certain kind. Now, the seller here had affected the shipment. So the court simply sympathized and did not grant the injunction which was prayed for. The next case, and also I'm being candid with you, a force majeure situation will depend upon the appeal it can create on the judge's minds. It is an equitable principle. Though it's applied in the law of contract, it's an equitable principle. It is a subjective assessment of the situation. In the second case, Halliburton, it was, I think, a development of some project. And this was an international JV doing a project for, I think, Delhi Municipal Corporation or one of them as a subcontractor, or for Vedanta, right? 30th March was the completion date. They went to court and said, sorry, I can't complete the project because of the force majeure pandemic happening. The Delhi High Court said, yes, this is a pandemic, so I am, for the time being, preventing the penal consequences that would follow, and granted the injunction. Of course, this is all temporary. What will happen finally, no one knows. The third case is also of a IBC case, insolvency case. Insolvency case where the resolution professional, I think I'm getting a bit technical. Let me make it a little simple for every one of us to enjoy it. Now, this was a case where the company concerned was in insolvency. The company was represented by resolution professional, and he came and asked for injunction regarding a bank guarantee, which could not be, because the company hadn't gone to liquidation. It was still under administration, that the contract couldn't be performed. The Delhi High Court in this case granted a stopgap injunction, even though the appropriate forum was National Company Law Tribunal. Because the explanation was, I can't go to NCLT, so you give me an injunction. And the court gave a stopgap till you can approach the NCLT. Last case was Indrajit's Power, recent order of Delhi High Court, where Delhi High Court again refused the, here it refused the injunction, refused to accept the force majeure contention, because it found on the facts, Delhi High Court found that that Indrajit Power had defaulted since before the COVID pandemic broke out, and that the lockdown was declared. So, Delhi High Court, after analyzing the facts, they said, yes, even though today there is a pandemic, but you could have avoided it had you performed in time the earlier, originally. So Delhi High Court again refused the injunction order and refused to accept the force majeure. So Kunal and Mr. Chandra Shekar, this would be a factual situation. I am not addressing how the banking laws have been, the banks have reacted, because that's a different chapter, of course, of fallout of this pandemic, but it's a different chapter. But here, so Kunal, I think I've been able to answer the query. It's purely factual, and that's how the courts will react to it.
Mr. Mitra, I think you've done a classic job by giving good examples, but also a classic senior advocate job by passing the burden on the solicitors. You cast the entire burden now on the solicitors.
No, on the judges. On the judges.
Don't treat the force majeure as a sunset clause or the last clause to be made, as I was always complaining about a dispute resolution clause. People don't pay attention to it. You've cast the burden on the solicitors. And I'd like to take this discussion a little more further, that if the solicitor, God forbid, had missed a force majeure clause, does Section 56 of the Contract Act come to your rescue? Frustration,
you mean?
Yes.
Frustration will be depending upon the fact scenario. If it's a contract to be performed over a certain period of time, then this pandemic will not frustrate the contract. But say if it's a case of, if you take a property where there is no force majeure clause, there is a contract for lease of a property. Say for 2 months, months of April and May. Of course, force majeure will frustrate the contract. 56 will apply. It will be frustration. The lessee will have the option to come and tell the lessor, sorry, I will pay you nothing. You go to court and I'll face you there. On the other hand, if it's a 5-year lease, then certainly there will not be frustration, because this will be, at the most, there may be a suspension under a different branch of law, suspension of rent at the highest. But frustration certainly not, because it doesn't render the purpose negative. Similarly, if it's a contract for delivery of goods, where time is of the essence, it has to be delivered between, say, 1st of April and 30th of April, a large quantity of goods manufactured and delivered, and no stretching of time beyond that, it will be frustrated. So Kunal, there is no absolute answer to the law of frustration.
Thank you, Mr. Mitra. I think that obviously takes us to the other part of our discussion, which is on the real estate side. You just mentioned that the lessees will have some option to take some relief from their landlords. And during our interactive discussions academically, which I would have with you, you had mentioned some view which you had, which would be beneficial even on the real estate side. And would you like to share those views on force majeure on the real estate side? Because we do see some lawyers also fighting, and we did have some petition go up right up to the Supreme Court where the lawyers said we will not pay for the offices that we are occupying. Where do you see this in terms of large malls who are continuing to be kept shut? Where do you see in terms of large business models which develop only on leasing? And that will take straight to the banking obligations thereafter. So first, if you can touch upon what are the obligations, what are the troubles that you're seeing on the leasing business and the real estate developers recourse or the landlords recourse or the tenants recourse. And then how does this pan out into an obligation? Because all of those are leveraged projects. The projects are all obviously on some sort of mortgage or lease rental discounting. And you've got some orders from the high courts, which would be coming up on your slide once again, where the courts have interfered even in these situations. So what are your views? And I know you've got some dynamic views on this, which would be obviously shifting the onus thereafter on the judges.
Now, Kunal, as a fairly experienced lawyer, I don't have absolute views. Now, here also it will depend entirely on the fact scenario. Now, let me be clear. I am giving my answer on the premise that the lease or tenancy agreement doesn't have a force majeure clause. If it has a force majeure clause, finished. That's the last word. One has to look at the clause itself. But that's normally not there in a lease transaction. Now, if it is say a lease or a commercial space, say a 5 years lease of a office space, the tenant can't come and say, I will not pay your rent. It's as clear as that. Because you have got your space, you're occupying it, you have not surrendered the possession, so you are liable to pay the rent. A different situation may arise if the landlord, like many malls, shopping malls, are under an obligation to provide space for running a showroom. The access to the main premises is under the control of the landlord. The main entry, exit. Lockdown is declared. Can it be said that the landlord has discharged its obligation of providing a space expressly for running a retail inside his mall? May not be. So long as the lockdown is there, the landlord has shut the gate. I'm quite sanguine. The reciprocal obligation of the lessee to pay rent will be gone. The difficulty will arise when the lockdown is partially lifted. Is partially lifted. And the landlord permits entry of visitors. But there are severe restrictions. For example, say, not more than 20 people can enter at a time, or 50 people can enter at a time. The tenant has two options. If he opens the shop and runs it in spite of knowing, in spite of this risk, he may be hauled upon by the landlord to pay the rent. That you took your chance to open the shop. There will be some shopkeepers, there will be very many in fact, who will say, no, it is not worth running the showroom, opening the showroom now. Then the question is whether the landlord is discharging its reciprocal obligation to provide a suitable space for running a showroom inside a mall of the repute and status the mall is. Or in other words, the rent is based on the location, the likely footfall at the mall. That will be a very arguable case. I really can't say which way it will go. But in this partial lockdown period when there can't be a full flow of customers and the shopkeeper lessee decides to keep his business shut, it will be a very arguable case. It has to be seen. Although the judgments are known to all of us, starting with Mungri Ram Bangar's 50s, Justice Bijon Mukherjee's judgment, up to the most recent Global Energy by Rohinton Nariman. But none of these cases have considered a situation like this. So from real estate point, I'm not aware of any matter going to court as yet, because it's too early. Landlords are not asking for rent now. When it goes to court for this midway situation, let's see. Kunal, that's really my answer to your.
Sir, you've touched upon what you just said is the energy watchdog case, and Justice Nariman in his judgment really boiled that down to when it comes to frustration. He talked about events preventing performance. He talked about the financial or commercial difficulties or unanticipated change of events. And he also talked about the complete shutdown position where the transportation of goods or raw material became impossible. So keeping in mind, we have a question from one of the attendees, and it's a pointed question, and I know it may be a little repetitive, but let me ask you this question. Can the tenants running commercial operations, where there are no written contracts or protective clauses, refuse to pay rent, taking recourse either to force majeure or Section 56?
Kunal, I do not think the tenant can refuse. Unless, as I said, that there's a written agreement providing expressly for using this as a particular space, as a showroom, or as a commercial, or a go-down, or something of that sort where movement of goods is necessary. If it's a pure and simple unwritten contract, or what we in legal parlance call the monthly tenancy, which is borne out from the rent receipt only, so long as the tenant does not give up possession, he is liable to pay.
Right. Sir, to close the chapter on the real estate side, there is one small question which needs to be addressed. We know that the real estate world went into a regulatory regime after RERA came in. And this would really be a situation whether a real estate project developer is entitled to some additional time for completion of the real estate project, considering the lockdown, considering the force majeure situation. Because like Mr. Chandra Shekar said, there is obviously a bilateral disruption. There could be even a disruption in the supply chain of him getting raw materials. So he may, willing or wanting to even now complete in situ construction, may not be getting his raw materials in time. Where do you see this being viewed, and how do you see this being viewed in the regulatory regime of RERA?
Here also, like in many cases, IBC, I mean the banking transactions, laws of limitation, there have been laws have come in extending the time of the time for performance, like the time within which a suit can be filed. There is a 3-year limitation normally that has been halted. Then for banking transactions, there is under the prudential norms, a bank has to declare an NPA after a certain number of days default. First SMA1, SMA2, then NPA. That has also been halted by RBI directive. In RERA also, we expect certain statutory intervention extending the timelines. I'm not sure exactly whether the RERA has timelines regarding performance of the contract, or in other words, completion of the project. That I think is left to the contractual terms, because really the cases have not reached that advanced stage in RERA matters. Now, it's in contractual term, if there's a say 3-year timeline for completing the project, of course, this time period will be excluded. Why? The time during which lockdown happened, construction couldn't take place, will go out. No court in its true spirit would ever hold the developer liable for not being able to complete the project within the time frame fixed in the contract, ignoring the lockdown period. Now, the next part, as you asked, Kunal, which is more pertinent, is say after the lockdown, when the movement of materials gets hit because of certain restrictions on transportation, like this staggered lockdown situation. There it will be a matter of fact to what extent it interrupted the project. Here also, I would like to show one of the pages in a similar situation. Let me see if my office can help me with the screenshots. Let me see if I can find out that particular judgment which I'd anticipated this query from the business world, because let me see, sorry, I am not very tech savvy, unfortunately. Not this judgment. Let me see if I can open it. It's a very interesting case. Yes, just see the, where is that judgment? Anyway, let me go back, let me tell you a matter where this situation happened. Yes, now I've got it, which is the case. In the context of banking law, let's come to the judgment of Junior JR Toll Road Private Limited versus Yes Bank. This happened recently, a few weeks back in I think Delhi High Court or Bombay High Court. There it was a toll operation. In a toll operation, something akin to the development, the toll operator came and said, I should not be made to discharge my obligation to repay the banks because the repayment is through toll collection. The court, for the time being, gave relief to the bank, to the toll operator, and said till the lockdown is completely lifted, they will not be under an obligation to resume payment. But of course, this is an interim order, again I'm saying, but there's no relief against interest, etc. Similarly, I expect the courts to deliver orders which would suit the real ground reality, as in when there is staggered movement of traffic, of raw materials, the court should give concession to the developer to complete the project. And some extension of time will be inbuilt. That, I think, answers your query, Kunal.
Thank you, sir. Mr. Chandra Shekar, I think we've largely covered the aspect of force majeure, or the situations that you anticipated coming up for challenges in terms of breach and obligations. Before I move on to the banking and finance side, would there be any comments for your side that you think which needs to be addressed?
Yes, thank you. In fact, Kunal, for giving me that opportunity, because there were actually a couple of questions that came to my mind as Mr. Abhrajit Mitra was speaking. Two, three points, and if you permit, I'll just flag all of them and then let him respond as he sees fit. He mentioned that if there is a specific clause and it covers the pandemic, then of course that will prevail. But my understanding of most of these contracts is that they do not explicitly have any provision with regard to the pandemic. In fact, that was not anticipated at all. So if it is just a normal vanilla type of force majeure clause which does not mention a pandemic, how would that be viewed? And will it just be then based on the common sense and what appeals to the judge's sensibility based on the principle of equity? So that is one question. The second point that he mentioned was that, this pandemic has in a sense caused a timeout of, let's say, 2 months, 3 months, or maybe even a little longer, depending on how long the lockdown goes on. And for an ongoing contract for supply of goods or for a tenancy where the occupation continues, the contract is not frustrated because it can still be fulfilled with some delays. Therefore, the contract remains. But in all of these commercial dealings, there is a cost of the delay. And even if you take shipments, there could be, for example, for goods which are stuck at a port, because the port itself, port operations have stopped. There could be costs like demurrage and so on. So who will actually end up bearing the cost of this unavoidable delay? And is it the buyer or the seller or the financial institution in between? So all of these, how will they get dealt with? Any insights, I think, would be extremely relevant. And finally, I think, again, the question is, it appeared to me that a lot of the points that have been made are largely in the domestic context. Would it be a little different if it is in an international context is the third part. So these are the 2 or 3 comments that I had as I was listening very carefully to Mr. Mitra's, views.
Mr. Mitra, what Mr. Chandra Shekar says is the obligations of pass-through, it has always been under the system. And if this cost is now mounting, if the cost is rising, where is this burden going to shift? To globally, if the cost is going to change, and what is the impact of this on the international world now that you see, on the international contracts that you see? We did see what happened, Mr. Chandra Shekar, you would have seen on the slide that Mr. Mitra put down. Halliburton is a classic example. The Indian courts are very cognizant. You use the right word at the moment, equitable. However, this is all a pro tem arrangement. It was a time where everything was unanswered and we all suddenly locked ourselves into our respective homes. And the courts came to rescue virtually to their best possible method. Advocates tried their best to present their case virtually. And whatever the judges felt equitable in those circumstances, the answer is seen in those pro tem orders. Legally sustainable post things being normal, post things being semi-normal is a big question mark. And it's anybody's guess, as Mr. Mitra in his own experience is also saying. It's a large guess as to we don't know how finally this will all be viewed. However, Mr. Mitra, where do you see this entire burden shifting? Would it be really a realm of rewriting of contracts, and which is going to be my next question, because even in the banking and the customer situation, the judgments that I quietly now looked up on your slides, which you were putting one after the other, there is a situation where the old age concept that the courts will not rewrite the contracts, but in the pro tem arrangement, we see the courts interfering and sort of giving some sort of an equitable relief, trying to rewrite those clauses of obligation. So where do you see all of this in terms of the court's perspective, in terms of the global obligations perspective?
Kunal, let me answer Mr. Chandra Shekar's queries point-wise. They are very relevant. First one is, if there is a force majeure clause without reference to this kind of a pandemic. I'm quite confident if there's a force majeure clause in the contract, there can't be more obvious force majeure situation than this. Unless, of course, it's an information technology contract where everything is done in-house. But barring those, act of God, this situation is squarely covered. And force majeure will always have act of God or something of that sort, or even the word force majeure alone will take care of it. Now coming to the more subjective one, that is the cost factor. Now assuming we take a case where there is no price escalation clause in the contract, which can meet the situation. If there is none, here this will be a question of, this becomes very technical, section 55 of the contract, delay. Now, if it's a time-bound contract and the performance and the contract is not terminated on the ground of frustration, impossible to perform the contract, say by the supplier, and he agrees to proceed with the contract, and the buyer waits for the supplies to be made. The supplier will most likely in law face a situation where he can't ask for escalation in costs. That's a purely equitable concept, which if incorporated in contractual matters would be rewriting the contract. If time is not the essence of the contract, say if the goods are to be supplied over a certain period of time, the supplier sees this situation. He should then again very timely issue a notice saying that this contract stands frustrated. It's impossible to perform the contract terms on these terms. How far the court will accept it's a different matter. But this is how it should be done. Then the buyer will have the option to say, very well, I'll give you escalation and you continue the supply at a higher cost because the costs have gone. Problem is solved mutually. Now, if the seller does not give a notice of that sort, and then after performing, after supplying, says you should compensate me for the additional costs I have incurred. It was impossible to perform within the time period, and the extra time came with the additional costs. Most likely, if the courts follow the letters of the law, then in that case, there's no silver lining for the supplier. So far as building contracts are concerned, if there is no escalation clause in the contract, most likely the builders will meet the same fate. Here also, the builders, the developers, I mean, should immediately throw in a letter. How the court will treat afterwards, it's unknown. That you have the option of taking back your money and terminating the contract for purchase of flat or whatever. Or if you want to proceed with the contract, this will be the additional cost per square feet, which you'll have to bear. If this is not done, then it will be a bit difficult, I dare say. It will be a bit difficult. And what about the third? International transactions. International transactions, if it's a third international party and a domestic party, let me tell you what is the final law, what is required to be first addressed before I come back to the case which I had referred to earlier, that GS Global or something of that sort. Not, let me see if I can open that page. Yes. Now, before I come to the GS Global case, let me first talk about this case, Standard Retail versus GS Global. Here also, this was a Korean party who was the seller of the goods. The contract provided that the Korean law will be applicable to the particular transaction. Or in other words, what we call the law of the contract was Korean law. Finally, I personally feel it will be seen, the final outcome, what the Korean law provides for a situation like this. Like we have 56 of the Contract Act. We have 51 to 54 reciprocal obligation, 56 frustration. What the Korean law provides. But for the time being, the stopgap measure, the Delhi High Court just gave some, was willing to give some protection without looking at the underlying law contract, the law applicable, but did not give it because of the fact scenario, which will be generally applicable to both the laws. But otherwise, if there is a law of the contract specified in the contract document, the law applicable to the contract, then it has to be seen in the context of that law, whether this would be a ground on which legal obligations can be, a party can be relieved of its legal obligations or given some succor. But that will most likely be decided in a forum, in a neutral forum, as in arbitration, maybe somewhere else, and the law it will be an international law approach to what is the underlying contract law applicable and how that law would deal with the situation, which I really can't say what Korean law provides. In another case, it may be Iraqi law, somewhere maybe Nigerian law, that will be depending upon the law of that particular land. That, I think, will answer your query. Or if I missed out anything, Kunal, tell me, then I'll...
Thank you very much, sir. We'll move on to one fundamental question, which is coming commonly on my screen also from most of the attendees. And the question is, whether do you see this pandemic, or whether can it be conclusively said that this pandemic is an act of God?
Well, even if it's not an act of God, as Mr. Donald Trump has been saying again and again, so far as it comes to India, it will be an act of God. Because just in case Mr. Trump is right and this was bred in a laboratory in Wuhan and intentionally released to the mankind by the Chinese government, even if that is so, when it comes to India, it is an act of God. Certainly, it was beyond the control of the two contracting parties. It was beyond the control of the government also. The government declared a lockdown and is continuing with the lockdown. So it will certainly, in India, we can safely assume it will be an act of God, irrespective of what is the final verdict of the international law courts as to the cause of the pandemic.
So we have also now moving on to the banking world, because the government of India was being constantly called upon to come up with some sort of a stimulus, some sort of a package. We all saw that there was a shift of the burden on the regulator, which is the RBI. The RBI then came up with some sort of guidelines and made it completely discretionary for the banking companies to take their own decisions at their own discretion, selectively with their own customers. And with that kind of situation, I think lots of banking transactions reached even the court of law. What, in your experience, and how do you view these orders passed by various courts in banking relations? And how have the courts intervened in the present situation in banking relations?
Kunal, you're absolutely right. It is discretionary. That 27th, that 17 March or 27 March RBI circular, which says that the banks may not declare an NPA for a certain period of time because of the COVID pandemic. But the courts have so far treated this as an obligation of the bank. There's a legal principle also behind it. When a power, a discretion is given to you, a right is given to a party, to an authority, not a private party, to an authority, statutory authority, to discharge certain obligation, to do something, that right comes with the obligation to exercise that right, or in other words, grant the extension when the situation so demands. And that's how the courts have reacted. Let me just see if I can show some slides from my office. My office can take it out. Yeah, I think I'll be able to get it. Yes. Each and every case, almost each and every case, let's take the first one, rural fair price versus IDBI trusteeship. There was a threat of sale of the pledged shares by the bank. Because here there is no RBI guideline says that sale of pledge, that the invocation of pledge won't happen on default. This is not covered specifically by the RBI guideline. Leave aside the discretion issue. But the courts, for the time being, stalled the sale of the pledged shares because repayment obligation could not be discharged because of the pandemic, lockdown. And consequently, the invocation of the pledge was perhaps not called for. And this order was taken up to the Supreme Court and stood the test of time. Similarly, you will find ideal toll and the next cases. But what is interesting in all these cases, as is a very commonly known saying amongst lawyers, equity shifts with the chancellor's foot. The courts, different situations, in all these cases, have imposed different conditions. In almost all these cases, the courts have imposed certain conditions. Very well, I am saying that let the sale of pledged shares not happen, or declaration of NPA not happen. But subject to a condition that you repay after, you clear up your default after a certain time. In some cases, the courts have said, have fixed a time, exact date by which whatever was the defaulted installment, you got to pay up by that, say by 26th April in one case. Say, this is Anand Raj. By 25th April, you've got to clear all the defaulted installment that was due up to. Actually, it's a typographical error. It is 1st January 2020. It should be paid up by April 25, 2020. In the next case, that Transcon Iconica or whatever, it was, you've got to repay the defaulted amount within 15 days from the complete lifting of lockdown. Like in Shakuntala Educational Welfare Society, there was no repayment condition at all imposed. And the matter has been fixed another date in the month of May, possibly it was today. And for the other courts to consider this aspect. So I'm not going through each and every one of the judgments, but the conditions are being imposed by the courts. It is not a holiday forever. And there it will depend upon the facts of the case and the judge's mind. I'm sorry, we are here dealing with human beings. And how well you place the facts, how much sympathy you can evoke, it will depend upon that. Of course, certain basic facts have to be met, but the extra bit, what condition the court will put, will depend upon the exact fact situation and the judge's frame of mind. That would be my answer.
Now, you're aware that we now have a situation, or rather a law of the land being laid down, that even the cooperative banks have the right under SARFAESI. And that seems to be now the full bench verdict of the Supreme Court of India.
Could you just repeat? There was some...
No, so on the SARFAESI Act,
yes,
we now have a verdict from the Supreme Court of India, full bench, saying that even the cooperative banks have the right under SARFAESI. So they would be covered by the SARFAESI Act. Usually we've seen the courts restraining SARFAESI actions very, very rarely, or rather there have been very few instances where the court would come in the SARFAESI action. One of the judgments, I took a sneak peek on your slides, was under the SARFAESI action, which is the Ajay Kumar judgment, and where there has been a possession which has been given back to the borrower. What are your views on such situations? How do you see this legally panning out? How do you see this as an interference in the entire process of recovery?
Now let me come to that Ajay Kumar case straight away. Let me see. Yes. Here possession was resumed. This is also, these are all I'm telling you interim orders. Possession was resumed by enforcing a right under section 13.2 and 13.4 of the SARFAESI Act because of default in payment. The Delhi High Court said, give back possession. This, I personally feel, SARFAESI actions also, if the banks behave unreasonably, without banks or cooperative or NBFC or whoever is covered by the SARFAESI banking company within the meaning of the SARFAESI Act, if they ignore the ground reality of the COVID-19 situation, then the fundamental doctrine is a Latin phrase called lex non cogit ad impossibilia. Ad impossibilia. Or in other words, the law does not compel the performance of an impossibility. What is impossible? So here also the courts are bound to step in, barring exceptions if the facts are clear that the banks have, or the lenders have behaved unreasonably. But again, the courts will also impose conditions on the borrower. They will ignore the past precedents of non-interference, etc. And the courts will certainly interfere, but again put reasonable conditions so that there's a balancing of equities. That's my answer, Kunal.
Sir, one more genre of cases where the courts rarely interfered was public tenders. And one of your slides is also on public tenders. How do you see the courts during this pandemic, even jumping in public tenders?
You're possibly referring to this ideal toll case.
That's right.
There, if you see the facts, you would feel that the court was wrong. Because here there was a public tender for toll plazas. 100 plus toll plazas, 100 plus entry points into the highway. Huge contract, a huge public tender. An intending tenderer, bidder, came and said, the tender should be deferred because it's not possible for the public to come and, the interested tenderers to assess the situation, as in the traffic flow possible. The normal traffic flow, the situs of the toll plazas, the location, how many it can handle at a time, because we can't go there. There's no traffic now. Normal course, even a lawyer would feel that, yes, this South Delhi Municipal Corporation shouldn't have gone ahead with this public tender because there's a doctrine that maximum participation. But here again, the court did not interfere. Why? Because possibly what is, may not be in the reasons, but if you see the judgment, this is all interim orders, or maybe that the court felt that this particular prospective tenderer was an adventurer, not a bona fide a public tenderer. He was waiting till the very end. He did not make sufficient inquiries, did not try to submit its bid, etc. Also, I can get a hint that the court possibly felt that this petitioner was set up by the existing contract, though it's not spelled out. But then that could have been this behind the judges in the judge's back, in the back of the judge's mind. Otherwise, if I personally feel if a public tender is invited now of a large scale, this is absurd. And where the ground realities have to be seen. And it is not a tender which is so urgent, something relating to COVID, it should be deferred. Where the ground realities have to be assessed, it is not possible to assess because of the lockdown. That's my view, Kunal.
Mr. Chandra Shekar, I think where we see all this going, and as Mr. Mitra has reiterated, it all now comes down to the judge's mind. And that takes me to a very interesting proposition on a very lighter note.
Facts of the case, Kunal, and the facts of the case.
Artificial intelligence to come. Do we now need to start finding what our judges are thinking? Do we now need to start analyzing how the judge is going to react? And as a man of technology, on a lighter note, I feel that artificial intelligence will become very, very important for something to consider, because India incorporation now needs some certainty to understand whether I go to court, what's going to happen. But on a serious note, do you see that we now need a technological revolution? We are all able to even interact peacefully today thanks to a technological revolution which happened several years ago. You've been stepping that up in your duties as a bureaucrat. Where do you see and what do you see as a future step to be taken in technology, particularly to bridge the gap between India incorporation, to bridge the gap between the India incorporation, its lawyers, India incorporation, and its judiciary? Where do you see what is necessary?
I think the fact is that a lot of economic activity has now shifted into the digital mode. And enabling this, I think, has emerged as a very high priority for the country in order to be a part of the international trade and business. It's also gratifying that in this period, courts have used the digital mode far more, intensively and extensively than they ever did in the past. Lawyers arguing remotely, clients joining the proceedings remotely, judges also not insisting on a physical hearing. So I think that, this certainly makes access to the legal process much easier and simpler. But there are a few gaps which actually need to be addressed, and because of which in the past, perhaps we did not even go this far. But now that the situation has compelled everybody to actually go down this path, I think the situation that has arisen is an imperative to really look at what are the systemic, procedural, and legal limitations that we have imposed on ourselves based on legacy regulations and legacy rules, which once they are lifted, this convenience of having a case sort of being handled remotely, being able to get a service from a doctor remotely, all of that I think will open up. The moment that happens, a new set of legal issues will come up. You know, the liability and in what manner the current configuration of liability and rights and obligations would change when you perform these services remotely. It's easy to envisage, you know, how a situation is different when, say, a doctor is dealing with a patient remotely, and there could be even further complications when, for example, the doctor is assisted by new technologies like artificial intelligence, which are also prompting certain kinds of decisions based on global knowledge. So all of these are dimensions that are coming up. But having said that, I think we also need to recognize that the whole world is physical. Digital is one means of dealing with some parts of the physical world around us. And therefore, the physical realities will always be a part of this entire configuration. And I was, I think, somewhat, I would say, oddly comforted by Mr. Mitra's words that at the end of the day, you know, the judge is trying to apply, as a fellow human being, a sense of equity and, you know, the logic that would apply in a particular situation. And since all situations cannot be envisaged, we will have to leave some of these questions to the sensibility of a judge. And as long as we have a system of, you know, rule of law and sense of fair play, we can still hope for, you know, rational and equitable decisions to come from the bench.
Thank you, Mr. Chandra Shekar. Sir, before I move on to the last topic, one question that is being asked by many of the attendees is that does the rule of mitigation apply in force majeure situations? Is there an obligation to mitigate when you are seeking recourse to force majeure?
Very pertinent question. Mitigation is built in when you want to terminate the contract. When you terminate the contract and when you claim damages, then in that case, law of mitigation steps in. To what extent you should have lessened the financial implications by doing the needful at the appropriate time. Certainly, if one, on the ground of frustration, terminates the contract, of course, there the law is a bit different. Then there is no consequence. It's basically a return of each one's whatever they benefited. There is no question of damages coming in there when it's a frustration, when it's avoided. But if it's a case of damages, which I really can't envisage a situation, a claim for damages because of the pandemic. But let me be clear, whenever damages is claimed in a court of law, whenever a claim for compensation is made, the person claiming compensation would have to justify it to go to the court that the compensation it is claiming, or in other words, the damages it has suffered, is after discharging his or her obligation to mitigate the losses. So just offhand, I'm giving an example, may not be COVID related. Someone terminates the contract. One person wrongly, one side, say the buyer wrongly says, I will not take delivery of it. The seller goes to court and says, this is wrongful breach, compensate me. The court will immediately see what is the compensation. Did the seller immediately upon coming to know of this wrongful breach by the buyer in not accepting the goods, take steps to sell the goods? or just held on to the goods and let the goods become junk and claim the whole price or large part of the price. The courts, I mean, the law, not the courts, the law casts an obligation on the person, on the party who has not committed the breach, to do whatever a reasonable person should immediately do to ensure that the defaulting party is not saddled with a liability disproportionate to the situation. That will apply to all situations of law, even if a damages claim arises out of COVID-related issue. That's my answer, Kunal.
Yes. Sir, one last position, and you come from the world where there has been a labor revolution. Most India incorporations are now seeing a situation where they may either want to terminate services of laborers or employees. They may want to even reduce salaries during this entire period of lockdown, or even future salaries. The government of India has put down two advisories, and I term them as the March 20th advisory and the March 29 advisory. State governments have also issued certain orders taking recourse to the Disaster Management Act and the Epidemic Act. Section 188 of the IPC also looked to be invoked. Where do you see this entire situation legally?
You see, I am in fact handling a case for employers' organization, so I would not say too much as to the legality of it. But this 27th or 29th March directive of the government to pay the wages, exercising power, I think, under Section 10(2)(L) of the Disaster Management Act, is, according to me, possibly not a correct exercise of right. The government could not have, I mean, not the government, this is the National Executive of the National Disaster Management Authority constituted under the Disaster Management Act. They made an order asking the private parties to pay the wages even during the lockdown. This was, I think, beyond the powers of the authority. Well, this is under challenge in Supreme Court, and the matter is fixed sometime in middle of the month of May. Many petitions are coming and joining in, and one from the eastern side of the country is likely to join. Bombay High Court refused to intervene because the matter is pending in Supreme Court and deferred the hearing to a later date, and the matter is now at large for Supreme Court. Now, but let me be clear, though I'm not really, I'm more a pure commercial lawyer than a labor lawyer, but the labor laws, existing labor laws, require payment of 50%, I think, of the wages of the workmen, even during no work period. I think under the Payment of Wages Act, Section 7 or so. And even if there's a lockout declared, a layoff done, even then there is an obligation to pay part of the wages. This government's directive to pay 100% under the DMA, unless the courts take a very equitable approach, legally this, according to me, will be difficult for the national executive or the central government authority to really sustain it. But as I said, I would rather not comment because this matter is going to be heard in court very soon, and I may be appearing for one of the parties, so I should not say much.
Thank you very much, sir.
Vajani, if you permit, I have a small question for Mr. Mitra.
Very good.
You know, when you talked about the direction to pay salaries in full and the legality or otherwise of that order, one other dimension of this is the ability to pay. And what we are seeing is that some of the large companies which have accumulated reserves have the ability to pay, but the question is whether they have an obligation to pay. But for some of the smaller and mid-sized companies, it is actually almost an impossibility for some of them to pay. They just don't have the means. So in a sense, it becomes the impossibility of complying with that order, irrespective of its equity. Do you see any asymmetry developing in terms of how this would get applied in such situations?
Of course, I expect the government to come up with certain maybe subordinate legislation like a government order or rules which provide for payment by certain type of concerns, as in large-scale enterprises, but not for medium or small-scale enterprise. But Mr. Chandra Shekar, what you asked, it's more on moral side. Profit generating cash-rich company should pay, no doubt, absolutely. Discharge its moral obligation to pay all its workers 100%, even though it may, under law, not be required to do so. But short of the legislature, the parliament or the state legislature stepping in, making law, which is applicable expressly to certain class of organizations. Or in other words, say, if I just imaginary companies, cash-rich companies should pay 100%, and under the appropriate law it is made, maybe amendment to the Payment of Wages Act or something like that. Short of that, the courts will not be able to, or should not be able to, differentiate between a cash-rich company and a cash-strapped company. Here, it has to be the appropriate government stepping in and making laws, and make laws which should sustain a test in a court, and not something very hasty and without too much of an application of mind. That's, I think, my answer to you, Mr. Chandra Shekar.
Thank you. I think we've reached the end of this discussion. I'm glad that we were able to keep it more informative, because that was the focus and mandate from the ICC, that we try and disseminate as much as legal information as we can. Thank you very much, Mr. Mitra. Thank you very much, Mr. Chandra Shekar, for your kind views. I'm sure the attendees have to a certain extent benefited. Mr. Mitra has also been very kind to share those slides and laid out.
For that, you need to thank Mr. Mitra's office. His office has been very efficient.
You're right, Mr. Mandal, you know me too well that I am incapable of doing these things.
I do not doubt the source of knowledge, but certainly I must compliment your office.
Technology, yes, sir.
And I think we, can safely conclude that we still live in and under the rule of law. We live with equitable humans. We live with equitable judges, and we will hope that this sense of equity, which we as judicial officers are proud of, continues in the forthcoming times. There are various legal questions, and this discussion can go on and on. I have tried to cover up several questions arising from the audience. However, we're not going to be able to take everything, and we can try and reply to them separately if Mr. Banerjee wants. Over to you, Mr. Banerjee and Mr. Mandal.
Thank you, Mr. Kunal Bhai. Thank you, Mr. Mitra. Thank you, Mr. Chandra Shekar. All of you, made the whole session so informative and so instructive. It was, rather educative, but at the same time, it was not academic. Mr. Chandra Shekar, you really pointed out so many key and pertinent issues on the supply chain disruption, on its effect on cost, on the ability vis-a-vis the legality or impossibility to pay wages during the period of lockdown, which is indeed a question, like Mr. Mitra summed up, of morality versus illegality. It may be illegal, but I may be able to pay. But why should I pay? these questions Mr. Chandra Shekar has raised. Thank you, Chandra Shekar, for making all the time. Mr. Mitra has of course been very informative with the cases which he has shown on in his slide. They've been all up to date, the latest cases. He has covered a whole gamut of topics from real estate to SARFACI to labor, wages, and contracts, man guarantees, LCs. Of course, Mr. Bajani, you have rather moderated the whole thing with so much of elan. Thank you, all of you. Thank you, Mr. Banerjee. Thank you to ICC. And so I hope to see all of you again. And this time in a real world, in a physical world, where we'll have the pleasure of seeing each other across the table without the fear of COVID or without wearing a mask or a face cover.
Thank you. Thank you, everybody.
Thank you, everyone. Thank you.
Thank you, everyone. It was a great pleasure.
Thank you.
Thank you. Thank you.